Hello, everyone. Today we'll continue our discussion on direct democracy, and this is our third and final conversation on the topic. And we have a special guest. That's why the conversation will be in English today. And our guest is Raffael Fasel. Raffael is a research fellow at the London School of Economics and a constitutional theorist, and perhaps more important for these purposes, he's also a Swiss citizen and an expert in the Swiss constitution. So we will talk with him about the Swiss direct democracy system, but specifically we want to focus on how the Swiss direct democracy system plays out within the Swiss constitution. So what is the Swiss constitution? How it's structured, and how the system of direct democracy fits within the Swiss constitutional framework. So, hi, Rafael.
Hi, Crescente. It's a pleasure to be here.
Yeah. So, thank you. My first question is about the Swiss constitution. Could you tell us a bit on how the basic features of the Swiss constitution and how specifically the political system is structured and in concrete the system of direct democracy?
Sure, yeah, I'd be happy to do that. So the Swiss system is a federal system. So it's a federal state with states that are called cantons. Perhaps some of you will have heard that. It is a system with a pretty unique direct democratic approach, and I'm sure we're going to sort of talk about this in more depth, but perhaps just some sort of key facts. The direct democracy operates on basically all the levels of government, the federal level, the cantonal level, and the municipality level. There are different ways in which direct democracy is at work in the Swiss system. You have citizens' participation in sort of municipal lawmaking assemblies. You have citizen participation in at least 2 Swiss cantons that still have this institution called the Landsgemeinde, where you actually have sort of people acting as parliament, making decisions as parliament on the cantonal level. And then on the federal level, you have 2 tools of direct democracy, the so-called citizens' initiative and the referendum. The difference between these two being the following: most countries, to the extent that they have direct democracy, only have referenda, which are usually triggered by the government, or in certain cases, there's also the possibility of citizens to initiate this. In Switzerland, the referendum is a response that citizens can take to a law that's been enacted or proposed by parliament. So they can say, this law that is currently being created, we are opposed to it, and we want to have a general vote on it. That is what the Swiss call a referendum. But there's also the citizens' initiative, and that's the sort of bottom-up instrument that citizens can use themselves to provoke a popular vote on any matter, whether or not Parliament has discussed this before or not. And you will see this replicated also on the cantonal level, where there's referenda and citizens initiatives. So that's a sort of, I guess, a really rough overview here of the Swiss direct democratic system.
Okay, thank you. And how does, what kind of constitution do you need in order for this system to work? Are there any implicit commitments that a constitution requires to be, that must be in place within a constitution in order for such system to operate? As you know, in Chile, we are starting the process of designing our new constitution, and some people have been pushing towards the idea of establishing mechanisms of direct democracy. Does the fact of establishing mechanisms like the Swiss ones commit us to a certain type of constitution or not?
It's a very good question, and I think there's different facets to answering this question, there is a sort of an institutional aspect, perhaps the one that you're alluding to primarily. How is the sort of interrelationship between different governmental powers and the people structured in Switzerland? The second aspect, I would say, is perhaps a cultural one. How is direct democracy exercised by the Swiss on a daily basis, if you will? So perhaps let's talk about the institutional aspect first. The Swiss system is one, and perhaps some inferences can be gleaned from this for the Chilean discourse and indeed like considerations of direct democracy in other countries, is one where the main two actors, if you will, are parliament and the people, right? This is, I'm talking about the federal level now primarily. The courts have a very sort of minor role to play in this system. Now, the idea is here really a Republican one, if you will, right? It is the citizens that are coming together who exercise their freedom, if you will. The popular sovereignty, the people's will, is considered to be the sort of the ultimate source of legitimacy in the state, right? So whenever the citizens come into play, it is presumed that this is the binding sort of will for the state. The courts therefore have a sort of very marginal role, and that's sort of mirrored in different ways. For instance, the courts have pretty much no role when it comes to limiting the exercises of, say, citizens initiatives or referenda. There are only two sort of procedural limits that are more or less negligible for our discussion here, and they are rarely at stake. And there's really only one sort of substantive limit that can be imposed on citizens' initiatives, and that's the limit of violations of jus cogens, the sort of peremptory norms of international law, whenever a citizens' initiative was to violate such norms, say it, endorsed, I don't know, perhaps torture in some form or genocide or whatever. Of course, these are sort of very far-fetched scenarios, which is why never ever has a popular initiative been declared unconstitutional on these grounds, on the grounds of jus cogens. So aside from that, there's a lot of sort of, indeed, almost absolute discretion here as far as what the people can do. In fact, it wouldn't even be the court's role to check on the legality of these initiatives in the first place. It would be Parliament who's tasked with checking these limits. They're considered more political limits indeed, rather than legal limits. Now, of course, I did say at the beginning that Switzerland is a direct democracy. It is actually more accurate to call it a semi-direct democracy. I mentioned the role of Parliament as well. And of course, Switzerland is not the sort of very small state any more than it used to be, perhaps in sort of romanticized notions that even, Rousseau indulged in at the time. Even then, I think Switzerland and Swiss cities already, were of a size where his notion of a sort of really small group governing themselves was already outdated, you could say, or sort of idealistic. Now, that is why you need someone to actually run the sort of day-to-day lawmaking affairs, if you will, make the laws, come up with the projects. And so Parliament has a very important role in the Swiss system. Again, and that's perhaps something we can talk about later, this is an aspect where the courts have a very marginal role. They do not, as a rule, there are some limitations, have judicial review powers. Happy to talk about this. So this is perhaps as far as the institutional aspects are concerned, but I also mentioned the cultural aspects. And so perhaps something that I think is quite important to consider is that direct democracy in Switzerland is part of a large culture that historically has grown over many years. So historically, if you go back, I'm not a historian, but the inception of forms of direct democracy go back to at least sort of the Middle Ages in Switzerland, where sort of assembly-based gatherings that, decided, as I mentioned before, the Landsgemeinde that still exists today, on, basically the laws that they wanted to govern the specific communities. You had that in other parts of the world as well, of course, sort of Athens, if you will, other areas during the Middle Ages. This was institutionalized in the late 19th century. So Switzerland was founded as a modern federal state in 1848. And only in 1874 was the referendum introduced on the federal level. So these are the sort of people acting on parliamentary statutes, if you will. And in 1891, the Citizens' Initiative, so this other direct democratic tool, was introduced on the federal level. They had already existed on a cantonal level before that. So there is a relatively long history here with not just sort of assembly-based direct democracy, but also sort of vote-based, if you will, initiative referendum-based direct democracy. Today, I can give you sort of a concrete example. A Swiss citizen every 3 months will get a letter with like the upcoming vote that's ahead. So you might have, you know, a list of 2 or 3 things that you need to vote on the federal level, then maybe another 2 or 3 on the cantonal level. Do you want to endorse, you know, the sort of the funding for a new school being built in your canton, or on the federal level, whatever sort of the political parties might come up with, and put in a popular initiative. So this is a sort of almost a daily affair that you're involved in. And it is also reflected in other aspects of what the Swiss model sort of represents, the culture, if you will. The Swiss system is based on what's sometimes called a sort of a milice system. It derives apparently from the term militia, and it does affect sort of how citizens participate in the military. So we still have a mandatory draft for men, for instance. But it's also understood in a broader sense. So parliamentarians, for instance, are considered to be sort of a militia in the sense that they consist of ordinary people who go there, but they're not professional parliamentarians. They have a job on the side. They might be a farmer on the side, right? And this again is sort of represented in many different ways, where you could call it a sort of the civic duty as being quite an important part of how the direct democratic system in Switzerland works and how it is actually sort of driven. It's not just the sort of institutional norms. It is captured also in many different other cultural ways.
Yeah, that's very interesting. Let's talk a little bit more about what you call the Republican conception of a constitution, where the people are the ones that are sovereign in the ultimate terms. So the people are the one that have, say, the last word on what counts as the constitution, or what counts as constitutional in the given jurisdiction. That's what takes place in Switzerland. And so that commits you said, to, for example, not granting judges the ultimate word to decide, or the ultimate power to decide what counts as constitutional in the given in a given jurisdiction. So we could contrast the Republican model, you know, the Swiss model, with another model which gives, say, judges a lot of power to decide, or even parliaments, or supermajorities, or institutional mechanisms that are intended not to allow the people to express their will, but to do that. But at the same time, and more importantly perhaps, the role of the constitution would be to limit the power of the people and protect, say, fundamental rights through the judiciary. One example would be the American Constitution, the French Constitution, and certainly the Chilean Constitution. What is as a Swiss constitutional, as a Swiss citizen and as a Swiss constitutional lawyer, what do you think of these two models? Is there anything to be said for the American and counter-majoritarian model, or you prefer something like the Swiss model?
So it's a very interesting question, and I should say that I was perhaps emphasizing too much the Republican character of Switzerland. There are certainly sort of liberal elements in the Swiss constitution, the Swiss system, that would be closer to, you know, as you call it, the sort of American model. And I'd be happy to go into some details on that point. But on the notion perhaps of how desirable the Republican model, if you want to call it that, a model that is perhaps also close to sort of a political constitutionalism, where political accountability is important, right? I mentioned Parliament is the one checking on the validity of citizens' initiatives. Another example would be Parliament is the one that elects judges, the Supreme Court judges in Switzerland. They can be elected. There's sort of no limit on how many times they can be re-elected. The tenure is relatively short, so it's clearly a model of political accountability rather than sort of, independence, perhaps in the counter-majoritarian sense that you're alluding to. Now, I want to spend just a few minutes, if I may, on the perhaps disadvantages of what some might call an overemphasis on the people's sovereignty, right, through the Republican model. Now, as I mentioned, there's very few limits on citizens' initiatives, and that has become a particular issue in Switzerland since the late 20th century, early 21st century in particular, when there was a considerable upsurge in the use of the popular initiative on the federal level. Now, there's different sort of speculations as to why that might be. Essentially, from its creation as an instrument in 1874 to even 100 years later, I think it was only used maybe 10 or so times, the instrument, or very few times. Since then, we've really had a huge increase in how many times the popular initiative has been used. It may have to do with the fact that you only need to gather 100,000 signatures from the people in order to provoke a vote on a particular issue, right? And obviously, the Swiss population has increased significantly, so it's relatively easier for people to get the 100,000 signatures. There may be other reasons also. Some people suspect that sort of populist considerations play a part as well. And so the Swiss People's Party is a particularly prominent example here, that in the sort of early 21st century, the sort of early noughties in particular, has used the popular initiative for sometimes quite questionable sort of endeavors, or some people might see it as questionable at least. I'm mentioning one example that has made sort of international headlines: the ban on minarets. Right? Yeah, so Switzerland, you may have seen this in the news. Yes, Switzerland, at the time the ban on minarets was proposed, had a total of 5 minarets. Right. So some people might say, whatever you think of minarets, it wasn't a thing, essentially, right? It was, however, used to essentially well, I guess, get people to focus on problems in society they might associate with immigration, sort of 9/11 news, to garner the sort of the populist feeling, if you will, or support for this particular measure as more of an outcry, I would say, than perhaps a concrete solution or even legal measure to anything that could be regarded as, a legal issue, which I don't think it was, of course. What happened then was this provision was actually accepted by the Swiss people. It clearly violated the freedom of religion that is already in the Swiss constitution. It violates the freedom of religion under the European Convention of Human Rights that Switzerland has ratified as well, non-discrimination clauses that are being violated. But because it was accepted, it is now part of the constitution. Yeah. There's just one example. Another example, this didn't actually make it to the stage of it being actually voted on, but there was sort of talk about a reintroduction of the death penalty, right, which Switzerland has abolished, I think, in the mid-20th century or so. Now, there was a big outcry there, but we realized, well, in fact, there's nothing that would have stopped this initiative from coming about, because it doesn't violate jus cogens, right? If 100,000 signatures have been gathered and this had made it into the constitution, then so be it, right? This would now be constitutional law in Switzerland. And there has been a trend, a sort of the liberal trend, as I invoked before, that has sort of started to question this, started to question whether, in fact, there should perhaps be some more limits So what has been proposed, for instance, is use the so-called core content of fundamental rights, so the sort of the really central aspects of fundamental rights, as a potential limit that would render certain initiatives unconstitutional.
By parliament or by the Federal Assembly, or courts would be entitled to strike down those laws or the initiatives?
So yes, it's an ongoing debate essentially as to which particular institution would be most suited, and there's talk essentially about, perhaps the Supreme Court, perhaps Parliament, or perhaps even at an earlier stage where before the initiative even gets to having any sort of signatures taken in its favor, it is rejected by some sort of the chancellery, basically. Yeah. So that's one other proposal here. It has sort of ebbed down a bit, especially because the Swiss People's Party hasn't been very influential anymore with its popular initiatives, and it's not seen as a very burning issue at the moment, but it might flare up again soon.
And isn't it a natural response to the fear of populism within the Swiss system that, look, populism is everywhere you look at. So you go to the US, you go to Europe, you go to Chile, and there is populism, there is xenophobia, there's evil in the world. And there are institutions to channel those evil motivations, if you can call them that way. And there's a distinctive way in which representative democracies deal with them, which is creating populist leaders or xenophobe leaders, etc. And where people get frustrated, there's anti-elitism as well. There's a disconnection between the people and the elites, and there's tension and there's a political crisis somehow. We'll see it in the US. We would never expect it, large support for Donald Trump, for example, or in Chile, the institutions are in a very bad moment as well. Whereas in Switzerland, it's translated into people voting for stuff that we find objectionable. But don't you think, and tell me what's your personal opinion perhaps, and don't you think that the Swiss system, although it sees the same trends, right, because Switzerland is in the world, and but it channels those tendencies in a more peaceful way, perhaps, than the representative democracies, or if you had courts deciding, say 9 people in charge of, a constitutional court deciding, and not, half of the country.
Yes, I think, your intuition is a really good one here, and there is actually some evidence, I think, to support what you're saying, because there have been sort of popular counter reactions to what has happened. So I like how you present this as, it's a type of channeling. It seemed like an absurd provision now on the ban of minarets, but perhaps this was a way to let them sort of get off some steam, as it were. Yeah. And I think the system seems to be working to the extent that there have been popular, or I should say, sort of citizens' counter reactions to some of these proposals. So one of the reasons why the Swiss People's Party has been losing over the past few years, as I mentioned before, is that in response to these earlier initiatives that they won, there is now a sort of grassroots movement of more sort of progressive-minded people who have countered these initiatives in the sort of, stage where the initiative hadn't been enacted yet. There's sort of, media debates, and they've been really powerful. They've made arguments against, these initiatives and have convinced people, because ever since they have been rejecting those initiatives. In fact, there's even been instances where an initiative was enacted or adopted by the people, and the other side was so upset that they said, we're just going to now propose a new initiative that just undoes the old one, right? Yeah. So there is a way in which the system can itself cope with these, what perhaps different parts of the population might see as, negative tendencies. I think that goes to support what you're saying. And I'm quite sympathetic to that, I have to say. Although I would still sort of try to make the case that, again, as I mentioned, Switzerland has also got a liberal tradition. It is a country that, upholds fundamental rights. And it is, I think, a real question whether the mechanism of political accountability, whether through parliament or through citizens themselves, is sufficient in protecting these rights, or whether indeed you would need a court, perhaps a timid court, to at least exercise some form of constraint. So there is now a ban on minarets in the Swiss constitution, which negatively affects minority rights. Yeah. And this would be one of the things that could be prevented or at least curtailed to some degree by courts.
Yeah, that's very interesting. And I've been thinking that perhaps for the Chilean case, that something like that would be the best model, since the Constitutional Court is very unlikely to go away. There seems to be consensus that we will keep it. But I would like to see a Constitutional Court that has not the last word on constitutional matters, right? I mean, but they can nevertheless provide a constitutional interpretation as a kind of authoritative advice, if that's not an oxymoronic statement, but something that is not just a mere advice, but is an advice provided by the Constitutional Court, saying, well, watch out, this might be unconstitutional, or this violates human rights. And then the people might change their minds and vote against it. And as you say, there's this sort of epistemic moral authority coming from the courts. But I tend to think, and this is the Chilean experience, that, and we're seeing it in the US as well, I mean, elsewhere, that granting power to 9 or 12 people, the number doesn't matter, 9 people who are very intelligent and wise whatsoever, but to decide what is the constitution in a given jurisdiction and which laws ought to be passed or not, tends to create more political tension and disagreement than to channel the tension. That's my intuition, just by observing what's going on in the world and in my own country.
Yes, I think that's definitely a very interesting observation. And perhaps to support what you're saying, the Swiss Supreme Court justices or judges are pretty much unknown. Even like law students, they might be as sort of mediatized as the ones in the US are, which of course also has to do with that limited function that they have. Now, to some degree, and this goes back to the conversation we were having before, the Swiss Federal Supreme Court has tried to take seriously its role, not just as a guardian of the constitutional system as such, by respecting people's sovereignty and parliamentary sovereignty to the degree that we have it, but also to protect fundamental rights. And one example is, and this has to do with sort of judicial review being largely inexistent in Switzerland. So what the Federal Supreme Court can do is it can review the acts that are cantonal, right? So anything cantonal, the Swiss Federal Supreme Court can judicially review on its compatibility with the Swiss constitution. But it cannot, in general, review acts of the federal parliament or indeed, decisions by the Swiss people. However, what the court has been doing is it has said that in fundamental rights cases, because Switzerland is, a party to the European Convention of Human Rights, if a federal law violates, or indeed perhaps even a constitutional norm enacted by the people violates fundamental rights, then we as a court essentially act as if we were the Strasbourg court, and we can turn down a law or sort of, really have a more narrow interpretation of the law in order to make it more compatible with fundamental rights. Because what would happen if we didn't? People would just take the case to Strasbourg. Strasbourg would rule in favor of them, and we, like the Swiss system, would have to change anyway. So we are now sort of pretending to be the Strasbourg court. So there's sort of a functional exercise of judicial review, if you will, in human rights cases that, again, I'm not sure to what extent could be seen as a model for other countries such as Chile. But I think it is an illustration for how a court tries to sort of straddle that gap between republicanism and liberalism, if you want to use these notions.
Yeah. No, I agree that having a right-based liberal culture, it's important for any modern developed legal culture, right? But the point is, are we going to enforce that culture through the establishing of something like judicial review, and then that requires further argument? I mean, that's basically the point. But I agree that promoting a constitutional tradition or a constitutional culture that takes rights seriously, it's something worth doing, right? So that's the Swiss Constitution has a list of rights, and that's completely fine. So we should sometimes people misunderstand the point of the Republican notion of the Constitution, where the people are the ones that have the final word on constitutional matters, with a neglection of the notion of rights or individual rights in the Constitution, that you can have both, right? That's precisely what the Swiss Constitution does. Yeah.
Yes, exactly.
Yeah.
Perhaps one other thought, and this goes back to what I was saying about sort of the cultural aspect of the Swiss direct democratic system. So what I would sort of caution, I think, for systems that are new to the idea of direct democratic tools is this idea that just to have it as on paper might not be sufficient, or at least it can lead to distortions. It can lead to its own problems. So I think, you can use perhaps Brexit as an example, right? A country like the UK that is relatively unfamiliar with the idea of direct democracy, where referendums are more used for, politicians to essentially, have people assent on some project that they find important, right? Rather than actually have a sort of bottom-up input from the people, right? So these are done on a sort of, non-regular basis, and the legal foundation is usually not clear, it's very ad hoc. And you might speculate that the people might just not be as familiar with, how this works, what the implications of these votes can be, right? It was just a sort of, wasn't supposed to be a legally binding vote, but now it has turned out to be. So there's confusion around that. And perhaps, sort of the responsibility that a culture that is more used to exercising these rights can perhaps also entail. So I'll give you one very striking example. So the Swiss currently have 5 weeks of paid leave a year, right? And an initiative thought, well, it would be nice to have like a bit more vacation. So why don't we make it 6 weeks, right? So economically, it would have been completely feasible, but the Swiss turned it down, essentially said, no, we only want 5 weeks of holiday, right? It would seem like the standard example that you would give to essentially discourage a system from enacting, direct democratic tools, right? Because the citizens would only sort of act selfishly, right? They would want more vacation, you would think. But so the Swiss decided against having more paid leave, right? Now, what I want to say with this, I think, is the system incorporating these tools would have to be relatively confident, or perhaps this will be a process, that these tools won't be abused, right? And that there's a sufficient degree of responsibility that comes with exercising them. And I'm not necessarily saying that the Swiss have it necessarily, but at least they have some more experience. Like, yes, using these tools.
Yeah. Well, the interesting thing is that it makes sense to maintain that you acquire responsibility once you acquire the tool and once you use it, right? And becoming aware of the dangers of that tool and the benefits entails in part making mistakes, right? And reading and so you can actually realize the kind of power you've got. So some people might say, well, you need this culture of responsibility in order for the system to be successful. So therefore, we are not to have it yet. But then we want to reply, well, the only way to acquire that culture is by having the system. So they go and
yes.
so
there is a chicken egg problem for sure, but I mean, looking at the, the Swiss history that I sort of outlined briefly before, we didn't get, all the direct democratic tools all at once, right? So I guess, the question is, for a system that is revising its constitution, like the Chilean one, where, there's really bad sort of experiences with overly sort of almost despotic, I suppose, constitutional courts.
Yeah.
Do you want to sort of go all in when it comes to direct democracy, whereas there might be no sort of previous experience with that system, or could there be a sort of more staged introduction of direct democratic tools? Perhaps that's a way of solving the chicken egg problem here, the catch-22.
Yeah, that might work. So now changing to another topic, but it's as you'll see, very related to this one. So we've talked about if you're going to have a republican constitution and you will have systems of mechanisms of direct democracy like the Swiss ones, you will want to have a constitutional court that does not have the final word of constitutional matters. We agreed on that. That's how it's Switzerland works. You can have this self-consultative or advisory courts, etc. We can agree on that. But what about another feature of the Swiss constitution that is, we can say that it's a flexible constitution. In what sense? In the sense that the people can, through a popular initiative, change the constitution. You just need 50% of the votes, and that's it. So in that sense, the Swiss constitution is a culturally important law, and that's it, right? And in what sense? In the sense that sometimes we associate the constitution with this very important agreement we make every 40, 50, 100 years, then we have to stick to it, until there's revolution or something like that, or if 2/3 of the parliament agree to change it, or 2/3 of the people or something like that. So there's some people that associate a constitution with rigidity and with lack of flexibility or lack of possibility of change, etc. That's certainly not the case in Switzerland, right?
Yes, absolutely. So it's a constitution that has pretty much no entrenchment, if you will, right? Yeah. It's an extremely flexible constitution. Indeed, I couldn't think of a constitution that is more flexible than the Swiss constitution. Yeah. As you mentioned, it takes a 50% majority by the people and the cantons to approve a constitutional initiative on anything, right? So yes, it is extremely flexible. I can give you some numbers. So since the introduction of the Swiss sort of citizens' initiative on a constitutional level in 1891, there have been 481 initiatives that have been initiated, and 345 of those have actually sort of collected the necessary number of signatures. And around sort of the success rate isn't huge, so the Swiss still tend to reject most initiatives, but there's still been 10% or so that have been accepted. So we've had, depending on probably how you count and with some complete revisions of the Constitution as well, at least perhaps 30 revisions or more. And again, there's constant votes going on where people could, if they want to, revise the Constitution. So yes, it is an incredibly flexible one. It does come at a cost, of course, right? And this goes back to our earlier discussion. The cost of it is that a norm like, say, I don't know, freedom of religion that we mentioned before, or indeed right to life, in principle has no more entrenchment, seems to have no more constitutional value than any other norm in the Constitution. And so say we have a norm on hiking trails, right? The Swiss love their hiking trails, but it's hard to make the argument that hiking trails are more important than the right to life, for instance. Yet, because of the flexibility of the Constitution, they have the same hierarchical rank, right? Yeah. So I think, what you say is definitely important. I think, it goes back to, the debates that we've seen in the US with founding fathers and the notion that shouldn't the Constitution be sort of the instrument of a generation, and with each new generation there should be a new, say, constituent convention, there should be a new constitution. So the flexible model definitely ties in with this understanding of that people should see themselves as the authors of the Constitution, right? This Republican notion. But then, as I suppose, trying to at least allude to, there are these other, sort of concerns. Is the hiking trail provision really of the same value than, the right to life or others?
Yeah, that's very interesting point. And I have 3 different questions on this, or comments on this point. So one is, in Chile, we're now, as you know, starting the process of writing a new constitution, and there's so much going on because people want to put a lot of stuff in the constitution, right? And that's fair enough. But if you change your mindset and you understand that the constitution is a growing tree that you can change, that people can adapt, etc., and you can change it. Say the constitution will be done in a year and a half. One day after, we can propose a bill, an initiative, a popular initiative to change it. We wouldn't be so anxious right now, trying to put whatever we want to put in the constitution. We would be more interested in creating the mechanisms for us to be able in the future, in 5 years, in 5 days after creating the constitution, in 10 years, in 20 years, in 100 years, to adapt that constitution so we don't have more political crises, constitutional crises, where there's something like a revolution in order to change the constitution, right? So it's interesting that flexible constitutions may appear as creating a less stable political system, whereas in fact they might contribute to create a more long-lasting, stable political system. Why? Because people of different generations will start, appropriating the constitution because they know that they have the power to change it.
Yes, I think that's a very powerful observation, and I would agree to it fully. Yeah, no, I think there's definitely much truth to that, and it would definitely take off some, pressure from the current process in Chile, I think.
Yeah,
if
absolutely.
This was,
Absolutely,
if this was understood.
It will take a lot of pressure because right now people are talking about social rights, about the political system, about and so on. You name it. There's a lot of parallel. This is one. Everyone is talking about constitutional matters, but if we understand that we don't need to gather every 40 years and put a lot of stuff in the constitution, but we can just gather now, this year, and create a constitution that incorporates the will of the people, as the mechanism to determine what counts as constitutional, we won't have this problem. And for example, you were telling me we've had a lot of constitutional amendments, but then the question that I would come back with, I would say, how many constitutional crises have you had? And perhaps the answer is 0, a genuine crisis where the constitutional order is destroyed and is replaced by a new one.
Yes.
So
since the foundation in
very many,
1849, there's been none.
Yeah.
Absolutely. Yeah, no, there's been none.
Yeah. Sorry.
I was just going to say, it's absolutely correct. I think with this sort of system, and I think it goes to, you mentioned the sort of the will of the majority, right? That would be enshrined in this constitution, the Chilean one right now, or others in other constitution-making moments. But of course, the will of the people changes, if you want to use that term, right? Majorities change, interests change in the population, right? And with a flexible constitution, of course, you can accommodate that. You're not stuck with a constitution that is really rigid. U.S. Constitution perhaps being one of the prime examples, where the courts have then got like a really creative role, right, in order to somehow at least sort of, bring the constitution in line with more modern values. So yes, all that you don't need essentially with a more flexible constitution. So yes.
And one final question that is perhaps more philosophical, but interested me to see. It interested me to see how you see it. So some people, as we just discussed, associate the constitution with lack of flexibility, with rigidity, right? With this promise that we made each other, say 100 years ago, and we have to stick to it. We can change it, but it's very difficult to change. That's, as I said, the constitutional paradigm that rules in Chilean constitutional culture. Whereas you tell me, well, the constitutional the Constitution of Switzerland, in terms of flexibility, is as any normal law, right? So the law regulating, as you said, hiking and fundamental right to life, etc., are the same thing in terms of procedures to change, etc. So what makes something, according to the Republican conception of constitution, constitutional, if it's not this, formal mechanisms of rigidity and it's kind of like the promise we made and we stick to it? What is the most important element of a constitution in this more Republican conception of constitution? Again, it's a more philosophical question, but it interests me to see how you see it. Yeah.
Okay, yeah, it's a great question, because perhaps also I wasn't very clear in what I said before. So I should say that the Swiss system isn't like the UK system in the sense that it wouldn't have a distinction between constitutional laws, if you will, and normal laws, right? Well, there's some dispute in the UK about that, but with parliamentary sovereignty, you wouldn't really have a distinction. It's the same process, right? There's only one process, right? So how could you make constitutional laws and non-constitutional laws with the same process?
We have that distinction, that's why.
So, yes, so I should have clarified. The Swiss system also has that distinction, right? So to make an ordinary law, the process for parliament, a specific one, we have two-chamber parliament. It's much easier, right? For parliament to make a constitutional norm or to create a constitutional provision, the process is more difficult and the people will be involved in that process, right? So there is a distinction between the constitution and normal laws, but because of the flexibility of the constitution, you would still have relatively or seemingly unimportant provisions in the constitution, right? That perhaps some people once found important and added by way of a citizens' initiative. In fact, in 1999, we had a complete revision of the constitution, essentially because the old one got really messy with, different initiatives, like putting, new proposals into the text. The structure wasn't as neat anymore as at least, the jurists would have liked. So we created a new one to put some order back into the constitution.
Exactly. So in Switzerland, just a majority of the population, the popular vote, can change the constitution, and only then. That's the point.
Yeah. So Parliament can also propose a constitutional change, but there will be a sort of a mandatory referendum, as it were. So whenever it comes to changing the constitution, the people will have a say in it. Yes, and it's a mere majority of the people and the cantons. So there's sort of some representation in there as well. That can approve this.
Okay. Well, that's great, and that concludes our interview. So thanks so much, Rafael.
Thanks for having me, Crescente.
Okay. Bye-bye.
Bye-bye. Thanks.